The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. Today, we are here for the oral argument of the case of Schmett and Appellant versus State Objections panel, and an intervener is Abby for Iowa. It looks like the parties are ready. It's my understanding Mr. Langholz will go first. He'll take half of the time, and then Mr. Dickey. Is that correct? That's correct. Okay, go ahead, Mr. Langholz.
Good afternoon. May it please the court, Mr. Ostergren, Mr. Dickey. I represent the panel of statewide elected officials charged with deciding whether candidates have properly qualified for the primary ballot. And we're here today to ensure that the laws governing that decision are correctly interpreted so that the people of Iowa can have the opportunity to vote for all properly qualified candidates in the primary they choose. If you strip away the noise and the admittedly high stakes, this is ultimately a narrow question of statutory interpretation. Does a signature on a nominating petition missing a date get to be counted? The majority of the panel said yes. The district court said no. And this question about three challenged signatures really rests on three statutes: 4314, 4315, and 4324 of the Iowa Code. The district court agreed that this was the critical and dispositive issue and took pains to try to interpret all three statutes to give meaning to all three. But in doing that, the court actually did not give meaning to the most relevant statute, the one governing, that answers the question, when should we count signatures on a nominating petition? And that's section 4314. That provision tells us that we don't count nominating petition signatures if it's missing the signature of the eligible elector or if it's missing a complete date. It goes on to say that it has to be a residence address, not a post office box, that it doesn't count if it's been crossed out or redacted.
We're talking about subsection 2C, correct? Correct. All right, so if you go on from the sentence that you're talking about, you go out right into the next sentence, it says, a signature line shall not be counted if the signer's address is obviously outside the boundaries of the district. Is it your position, Mr. Langholz, that somebody who is outside the district but not obviously outside the district, their signature has to be counted?
I think, to briefly answer, yes. The statute says obviously outside the district. I think you need to give meaning to the word obviously as well. I mean, generally speaking, where a person's address is in relation to the district should be obvious. The district lines are set by code, and there are many mechanisms to search and determine where the address, whether it's in or out.
Outside the district, they don't reside in the district, their address is outside the district, but it wasn't obviously outside the district. That's a signature that is not subject to challenge, and it must be accepted as valid for purposes of the nomination process.
I'm having trouble coming up with the factual scenario of where it would not be obvious whether it's outside, whether it's inside or outside the district. But if there was such a situation, the statute says obviously, so I think the fairest interpretation of the statute would be that it has to be obvious.
What is the importance of having the date?
I don't know is the short answer, and I think that's part of why there's logic to the legislature not putting that in the list of items that is required.
State's position, well, let me give you a hypothetical, explore it this way. Let's assume you had a signer who was underage. Is that a valid signature?
On how underage they are,
A clear case where somebody would not be eligible.
just to explain the why, I mean, the question of eligible elector is determined at the relevant election, and so it could be someone under 18 if you're close enough. In the situation of a 16-year-old, they're not an eligible elector, therefore it would be missing a signature of the eligible elector, and that would be a basis for
Provision would allow exclusion.
be 4314. So it says a signature line shall not be counted if the line lacks the signature of the eligible elector. If they're not an eligible elector, if it's a signature of a non-eligible elector, it would lack that.
Somebody's an eligible elector.
Age, residence, correct, and felony status, those items would, yes.
Each of those, how can you make that determination without knowing the date?
So again, the relevant question for purposes of age is the election we're talking about. So perhaps
Example to make it more concrete. Allamakee County petition, page 11, which is 43 in your record, has one signer on the page. Do you see that? Assume there's no date on that signature, and we learn that that signer was a naturalized citizen, pick a day, February 15th. How could the panel determine whether or not the signer was a citizen on the date she signed without knowing the date of signature?
I think that you're correct that the panel wouldn't be able to do that. So that would be a basis on which the signature could provide value to making that determination.
5 of the 6 criteria for being an eligible elector are dependent on a status at a particular date. So why would we not require the date to be part of the petition?
Well, that is a good reason for why 4315 does include that requirement. And the panel's not arguing that it's not required and that there's not value from having the date. Whether it's required on the petition is a different question of then
The panel then can't make a threshold determination of whether somebody is an eligible elector initial matter, right? They have to make that determination. So in this case, let's assume the campaign decided they weren't going to collect any dates at all. And as I understand your position, that's fine because the exclusion statute says that those signatures can be counted. So you could have an entire slate of 3,500 plus names and no ability for the state to determine whether these people were eligible electors. Is that your position?
the interpretation of the statute, which is the fairest interpretation of the statute, could allow that. Now, a couple caveats to that. First of all, if a campaign did that, and if a date was necessary to determine whether a signature line was valid, if a challenge was made, this person, at some point in time, was not eligible, and it depends upon, having a date, that would be a non-eligible signature is a reason that the signature line can be invalidated, and the not having a signature there may have consequences that could result in that signature line being invalidated, but it's not invalidated.
And I just don't know the answer to it. When a person takes out papers, like if I want to run for school board or something and I take out papers, wouldn't that date be verifiable when someone takes out papers? I'm trying to figure out, is there a window that we know that signatures had to have occurred from the date the papers were taken out, and you said to the date of election? Is that the window that we would be looking at?
As a factual matter, I don't know for sure Chief Justice Christensen. There are other indicators of the date. There's a date of election on this in certain situations. And the panel's decision, 1988 decision, relied on more than just other signatures being on the line and the dates. Some of the other facts that could be gleaned, including, in that instance, the name of the Secretary of State was on the form that was being used, and the Secretary of State took office on a particular date, and they were able to cabinet in that regard. So there certainly could be other facts that go into that, but there's nothing in Iowa code that sets a window in which signatures can be collected. Nothing that prevents a candidate from deciding years in advance, that they're planning to run for office and want to, have a substantial number of signatures and start collecting those. That's not prevented. And the panel is not arguing that dates aren't required. 4315 needs to be given meaning as well, and there's value to that requirement even if the consequence of not complying isn't disqualifying the signatures.
Any other statute where there's requirements for, say, 4 things, but only a consequence if you don't do 2 of those things?
Off the top of my head, I'm not thinking of another example, but the consequence and the 2 things are reiterated in 4314. 4314 says, here's where, when you decide whether or not to count or not count a signature. 4315 doesn't include any language that suggests that it's about what the consequence of failure to comply with any of those requirements are.
Why is the list exclusive? Section 14 has A, B, and C, but why can't we have other violations that lead to disqualification of the voter? So if we were having this debate 20 years ago, I think the question would be a lot closer. If you take a look at the code of 2002, the statute looks very different. There's not a laundry list of exclusions at all. 4315 would have been where you'd have to look. But over the last 20 years, the legislature has been active. Sometimes, one has to wonder, whether acquiescence, is purposeful or not. But we can see from legislative enactments.
Acquiescence. You take the position that because your board has historically, or the committee has historically, since 1988 at least, allowed these kind of exceptions. Is there anywhere that the legislature, or anything in the record that recognizes that the legislature would have been aware of that fact? Did that issue ever come to a district court, or was it always only at that level?
I'm not aware of the date issue coming to a district court. But the record of statutory enactments shows that the legislature has been very aware in this area. You can often see a pattern between a panel decision or a court decision and then a legislative enactment either ratifying it and making sure we don't have to fight about that again in the instance of adding the line about crossing out signatures. And then just as recently as last session, they added a sentence specifically directed to the objection panel saying any incomplete and missing information in 4314 or 4318, which is the affidavit section, shall be sustained, making clear the legislature wants strict compliance with those provisions. It did not say the whole chapter, didn't say chapter 43, it did not say, non-compliance with 4315, and a couple years before in 2019, again, added to the laundry list of signature requirements when the legislature's been this active, been that specific, and these are the situations where to count and not count.
That they left Section 15 off that list, and doesn't that support your argument today?
leaving it off of the mandatory exclusion or the mandatory sustaining language and never putting a date on the list of 4314 both. And ultimately, if it's close, it's appropriate for this court to err on the side of allowing the interpretation that allows the voters to have the opportunity to vote for candidates.
Tag on to something Justice McDermott asked. He asked, do you know of anything else that has like 4 requirements and only ramifications if you don't follow 2? I just off the top of my head thought of one, and I looked it up really quick. And tell me if you think this would be analogous. Termination of parental rights 600A.4. There is a requirement if a person wants to release custody, there's a really, really long, detailed laundry list of what you must do to release custody. And every subparagraph starts with shall. It shall be accepted only by an adoption service provider. Shall not be accepted. Shall be in writing. Shall. Then you get down to sub H, and it says shall be signed not less than 72 hours after the birth of the child to be released by all living parents. The 72-hour minimum time period requirement shall not be waived. Help me understand. Does that mean perhaps that all the other shalls they can be waived?
I'm not an expert on that provision of the statute, but I do. But I do think language that makes clear, with a shall not be waived language, would imply that the others may well be waivable. And similarly here, again, the legislature spelled out the consequences in 4314. It put no such consequences in 4315. And for those reasons, we would ask that the district court's decision be reversed. Thank you.
Dickey.
Madam Chief Justice, and may it please the court, my name is Gary Dickey, appearing on behalf of Abby for Iowa, the candidate committee for Abby Finkenauer, who asked this court to reverse the district court's decision and allow her to be on the ballot for the June Democratic primary. I want to address the questions that have been raised by the panel and get to the standing issue that we raised, because the court need not address the statutory interpretation issue, and perhaps the most narrow grounds would be to decide this case because the objectors lack standing. Justice McDonald, you asked about section 43.14. As I read that section, it is a limitation on the panel's authority. So it's not a section that grants rights to objectors. And so as you read section 43.14, it says that the panel is limited to disregarding a signature line based on those enumerated reasons. Now, an objector can look at the address, go out and do their own investigation, make an objection, and then they're entitled to essentially a contested case hearing before the panel, and the burden would be on them. So there would be a way to verify it, just wouldn't be on its face.
That the panel has to consider a signature from an ineligible elector.
No, that's not our position. If there's an objection made to an ineligible voter, then the burden's on the objector to prove that.
The date information is critical in making that eligibility determination in 5 of the 6 eligibility criteria.
It would be helpful, but I don't think it's necessary, and that's a legislative preference. Certainly the legislature could have limited the panel's ability to consider a signature line missing a date. They specifically chose not to.
Ambiguity in the statute or a conflict between 14 and 15, why would we interpret it to not require information that is essential to making the threshold determination of whether the signer is even an eligible elector? It seems like we would want that information to allow the panel to do its job.
And that's a legislative decision. They can go back and amend the statute, and that gets to the question of legislative acquiescence and legislative history. So if we go back to 1988, the question was decided by the panel in a written decision we've provided as part of the record. The legislature has decided not to do anything about that for 44 years. Now, contrast that with the Narcisse decision in which Judge Huppert in the district court employed substantial compliance with respect to the header requirement. And this court summarily affirmed, and then last term, the Iowa General Assembly changed that to require strict compliance.
4314, is it possible, to read this critical subsection 2C, that these are instructions to sort of what the authorities are supposed to do when they receive the petitions and review them? Don't count this, don't count this, don't count this. But it isn't a limit on what an objector can come in and raise. For example, an objector can raise that somebody, even if they're not obviously outside the district, resides outside the district, and therefore they weren't eligible to sign the petition. Is that fair?
I want to drill down. So an objector can object on multiple grounds. In fact, in Chido versus the panel, we objected to the eligibility of the candidate, which was considered pursuant to a 4324 panel. They can object to the eligibility of somebody's competency, and the burden would be on them. With respect to counting or disregarding a signature line, the legislature has said that the panel's authority is limited. They could limit it to the date. They chose not to, and this court can issue an opinion and they can act accordingly. Justice McDermott, to get to your question, there is an instance in which substantial compliance was allowed. That's the Dix versus Casey's General Store from the 2021 term. With the short truncated briefing schedule, we weren't able to flesh that out, but that's the drug testing statute. My firm was on the wrong side of that case, and this court held that substantial compliance with all of the mandatory provisions of the drug testing case was all that is required so long as the essential elements were present. Now, the essential elements to challenge somebody on a prima facie case basis based on the four corners of a document would be the person's signature to give you their identity, to give you their address so that you can compare it with the district's boundaries. And so if the court, if the legislature wanted to include the dates, they could have, but the failure to do so by the candidate doesn't undermine the essential elements of the requirements in 43.
Even though the form has a line for the date, 4315 provides that the date has to be placed in this on this form. All 3,500 people that signed didn't need to put a date on? Is that your argument, that no date was actually required on any of these?
That was the panel's decision in 1988. The legislature has not changed that, and the legislature has not empowered the panel to disregard a signature based on that. So that would be our position. But in this case, there is no argument that's been made before the panel or the district court that the objectors did not know the date or could not ascertain the date because it's just below. One is clearly an incorrect signature. The other is where somebody's address spilled over into the date and they didn't have room to put it. And the third one, you can look below. I guess it's actually sandwiched. You can look above and you can look below. And Madam Chief Justice, that gets to your point. There is no beginning date limitation. We do know the end date limitation, which is when they were submitted.
That it's open.
Well, I guess the absence of a limitation.
Because there's that form you have to fill out, and it says, and I'm looking at it right now, it's, just for example, it's the Cedar page, 53 of the appendix. You have to have all that stuff filled out. I mean, that's by statute. You must have the name of the candidate, blah, 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 which office is being sought. So how could you get signatures anytime if that part isn't filled out? I would think you're not going to have people sign a blank piece of paper.
Do a petition for United States Congress for the 3rd District for 2024 and start gathering signatures.
So that might answer my earlier question. There is no, I know that as long as the form complies substantially and has a certain information. So you're saying there are not actually documents to pick up, that there could be a date that shows what day you took out papers. You could start your own papers any time of the day?
Right. Those are just forms that are provided by the Secretary of State. I could develop my own form. Indeed, in Chapter 43, all I have to do is develop a form that substantially complies with what the Secretary of State's forms are. So again, the court need not decide this issue because the objectors lack standing to pursue this claim. There are two hurdles of standards that an objector must overcome. The first is the statutory standard set forth in Section 4324. And then the second is the aggrieved party requirement in 17A.19. And on the other side of the coin is the common law standing doctrine that this court has adopted. The objectors fail both of those. The record is clear that they are Republicans. They've not made any allegation, either sworn or unsworn, that they desire to participate in the June primary.
The problem with that argument, though, is we have an open primary. If this were a state that had a closed primary and made it so that these objectors could not participate, your argument would be stronger. But I'm troubled with the fact that we have an open primary system, which suggests that our system permits cross-party participation.
A couple of points to that. One is I'm not sure I characterize it as an open primary. We have same-day registration. Two, the language used expresses a clear intent from the General Assembly to have some limitation. And the third would be, think about the absurd results that could come into play if we look beyond this case. So for example, I think Justice McDonald, you've pointed out that somebody who's a felon is an ineligible elector, but they could still file an objection because theoretically the governor, between the time they file the objection and the primary or the general election, could grant them clemency, and then they could participate same-day registration. Same with an out-of-state resident.
Any person who would have, you're right, would have the right to vote for the candidate. So, so you think that the would have the right to vote for the candidate in the office doesn't have different meaning than vote for the candidate for a nomination?
Well, the office that's being sought here is the ballot is for the Democratic primary. So the petition's not for the general election.
Exactly, but 4324, which identifies who can be an objector, right, says any person who has the right to vote for the candidate for the office in question.
Right.
Why does that not mean the general election?
Would have the right to vote for the office.
Right. So
Here's why that's not a reasonable interpretation. It gets back to the absurd results that would arise from that. So anybody, a Nebraska resident, for example, could file an objection and proceed under that theory, even though at the time they can't vote in that office because theoretically they have the ability to change residency and have same-day registration. But so even if they establish the statutory standing, they fail under 17A and the common law standing requirement. And
This is, I'm assuming that the people who filed this case are not supporters of your client and would prefer not to have her on the general election ballot. But that's true in any one of these cases. That's always the case. And the courts always find standing. So how is this different?
That's not what this court said in Dickey versus Iowa Ethics and Campaign Disclosure Board. Justice Mansfield, you attributed the reasoning behind the challenge as to create negative press. I think a reason which the court held was not sufficient to warrant standing.
I don't think I quite said that. I said that if you prevailed in your case, the only outcome of that case would be a determination that the governor had reported this amount for this airline trip versus that amount that you contended was the value of the airline trip. And you already knew that in your mind, you know, what the value of the airline trip was, so that you hadn't been injured. There was no real world consequence.
Didn't. I knew a range, and I had to take on the burden to go and do the own research myself. That is more of an injury than what the objectors have alleged. Before the panel, they didn't allege any injury. Before the district court, they didn't allege any injury. They don't claim that they would have challenged the signatory signature had they known the date. They don't claim that it would change their decision. They don't claim they would register as a Democrat and participate. And so let's do the analysis that was in Dickey versus the Ethics Board, which is what is their personal and legal interest in the judicial review? And then two, how have they been injured? And not just a generalized grievance, how have they personally been injured in a way that the general public has not? And I can't even refute that because it's never been identified by the party or the district court.
In any one of these ballot access cases, the stake that the interest that the party that's challenging the other candidate has is that they support a different candidate and they would prefer that candidate prevail. And I mean, maybe they didn't spell that out in the petition, but I think we can assume that, right?
Ostergren to argue to you, as he did before the panel in the district court, that this does not implicate anyone's right to vote. And so the objector's right to vote is not at all affected. They have the ability to vote for whoever they want. They can vote for their candidate in the Republican Party, they can vote for the Democratic Party, or they can write in somebody. And so even if they're injured, which they haven't identified, and so I'm at a loss as to how to respond to an injury that has yet to be identified, but even if they're injured somehow, they haven't identified how their injury is somehow different than my injury or the injury of any other eligible elector in the state of Iowa. And unless they can do that, according to the Dickey decision, they lack standing to do that. They're not aggrieved. This is just a generalized grievance. And even if they had the remedy, which is to keep her off the ballot, how does that cure the problem that they are arguing, that it lacks a date? So the remedy has no match to the issue. Now, that's not to say nobody would have standing. Certainly a competing candidate would have a personal and legal interest and could assert it. Notably, none of the other candidates for this office raised an objection. So for those reasons, we would ask that you reverse the district court.
Mr. Ostergren.
Thank you, Madam Chief Justice, and may it please the court, counsel. I'm going to start where Mr. Dickey left off on the standing question. And Justice Oxley, you're exactly right. The statute refers to the eligibility to vote for the candidate for the office in question. Whoever wins the primary election receives the right to appear on the general election ballot. That individual does not receive a certificate of election and the right to possess the office for the described term. And so that statute gives standing to anyone who would have the right to vote in the general election. And that's what these objectors have, that right. And the reason that Dickey versus the Campaign Ethics and Disclosure Board is no obstacle, in that case, my friend Mr. Dickey sought to get an administrative agency to exercise its prosecutorial power against a candidate in an interpretation of how the disclosure rules worked. And that agency looked at it and said, no, we're not going to proceed. At that point, he has no personal, tangible injury from the agency that has the authority to prosecute that case administratively, deciding that the case had no merit. But here, the objectors by statute have a right to raise these objections.
In fact, what about that requirement? Assuming there's, in addition to a statutory standing requirement, Mr. Dickey has raised the question of injury in fact. What is your client's injury in fact? How are they harmed?
If we were in an Article III federal court, I think this would create more interesting questions as to where Article III case and controversy, and I apologize, there's a class action case from last term where the court goes on about granting a statutory right to sue without any, it's the credit reporting case where the credit report never goes out. I can't remember the name of it, I'm sorry. I didn't read that, or 600A, Waterman. So if I was in federal court, I'd be super nervous about that question. I think here, where we don't have the same strict Article III type of jurisdiction of the court, the fact that the legislature has given standing to any eligible elector who can vote in that general election is enough.
Dickey.
Very well reasoned, but it cashes out the same place.
My majority opinion in the clean water case, where I did apply an injury in fact standard. I think we do have maybe an injury in fact standard. What is your client's injury in fact? How are they being harmed? I mean, I think you know how, but maybe you don't want to say it, right?
I would say every voter has an interest in the orderly functioning of the electoral process. Which is why I didn't say that first. Because every voter has that interest, and the code gives somebody the authority, any eligible elector who wants to raise the issue to this panel, to raise these objections, can do so. And I don't know that I have a better answer than to say the code allows them to do so. And if the court is going to superimpose on the statutory grant of standing some sort of common law or constitutional principle of standing, I don't know where you would fit that into this court's body of cases on standing.
I mean, this is interesting. I've been on the other side of this, as you know, not only in the Dickey case, but also in the environmental case. But the majority of the court even adopted Lujan, which is a very, by some lights at least, demanding standing test. And so far, I want to give you another shot at it. But so far, you've had a generalized grievance and maybe a statutory provision that provides standing. But do you have anything beyond A, the general grievance, and B, kind of a claim that the statute permits you to proceed?
No, because they're not running for the Democratic nomination, so they're not competing with Ms. Finkenauer in the primary. So if I was one of the other, if my clients were one of the other candidates, then it's an easier answer to that question. I can tell you that the legislature has not written the statute to only allow other candidates to challenge. It has not written the statute to allow only party members. You could have no party registration and file this objection. And in a sense, it has created a private attorneys general system for the enforcement of this election statute. And if this court is going to say that essentially that can't happen, I would submit that that is a departure from this court's body of law. Even the cases where you've been in the dissent, I think it would be a departure from the majority's view of looking at where you have a statutory cause of action to raise one of these claims and proceed. I want to point out, and my friend Mr. Langholz, I think, has been put in a difficult position trying to defend the idea that the word requirement really doesn't require anything. I can't think of another provision in Iowa law where a requirement is defined by statute, but then nothing happens if you fail to meet that requirement. Now,
Sorry.
15, and there's a requirement that the petitions be fastened. When they're before filing, they have to be fastened and neatly arranged. And it says shall. If I had a stack of petitions and put it in a file folder and presented it to the Secretary of State and it was filed, would that be subject to disqualification because it wasn't fastened?
if that happened, the Secretary of State would hand it back to you and say, this needs to be bound properly.
Didn't happen. It got filed. That would be, in your view, an unlawful petition? It wasn't passed.
It would be a violation of the law.
Would it be disqualifying? Would you end up being disqualified because you didn't have a paperclip on it or staple or whatever?
Section, it's in Chapter 45. It's cited in our.
Because that's exactly where you went, was the 45.6, I think you said. But the provision in 43.15 does not have that same sentence. But that brought me to another provision of 45.6, which is subsection 2. The signing requirement in Chapter 45 does not require a date. Why is there not a date requirement in 45, but there is in 43? And what does that do for how important the date is?
So what I can tell you, you're correct. I mean, it says what it says. It says what you just said there, Justice Oxley. What I can tell you is the legislature has required the signature to be dated. It has described that as a requirement that shall be observed, and it has stipulated that each signer of the petition shall date their own signature. Now, there are reasons that Justice McDonald identified where that date is important. I would submit there's also a small but important anti-fraud aspect to this, and there's a footnote in the brief where I point out, I mean, we have experienced in recent memory candidates who have had petitions that turned out to be a fiction. Pardon?
Fraud.
I'm not making an allegation of fraud about these 3 signatures. We're saying that they're not dated properly.
Then lend more towards this being a directory rather than a mandatory requirement? The idea of the date?
No. And the reason, Justice Oxley, is the legislature uses the term requirement. It says it shall be observed, and then there's another shall in there to say that the signer.
And I didn't mean to interrupt your answer to Justice Apple, but it also says that it shall be bound in a certain way. Right, so I apologize. You can finish answering that question.
All I can tell you is from what I know about how the process works is the Secretary of State's office will not take that petition.
Took it. Assume they took it. I think it's an interesting question.
I don't know how we would ever be able to prove that. It would be a violation of the requirements of the statute.
But I'm going to push it, as you understand, but I think your position is that would lead to disqualification. And if a judgment was made it wasn't neat enough, that would lead to disqualification because the word shall is used.
It is. Now, the word neat is maybe of interpretation, and so we would have to get into what I think would be a difficult set of fact questions about how neat is neat enough that we don't have here.
For me, one of the issues, there's many issues here. It's a narrow issue, but a complex issue maybe. But the distinction between mandatory and a directory statute strikes me as germane here. And I will tell you, Sutherland will tell you, this is a general proposition, but Sutherland says where a provision of election law does not provide a remedy, the presumption is its directory. Presumption, rebuttable, but that's what it says. Doesn't that apply here, at least the presumption that because it doesn't provide a remedy, where remedies are provided elsewhere, there's a presumption that it's not subject to a remedy, and that you have the burden of rebutting it?
So that reading would violate another basic tenet of statutory interpretation, which is that the court will not, unless it's unavoidable, interpret a provision to have no effect.
Mandatory directory distinction in Iowa isn't that concerned with instructions to the government. It doesn't apply to private parties, does it? Or at least I haven't seen it applied to private parties.
True. So it would by its own terms, that distinction normally does not govern how somebody complies with a requirement from the government, a private party. Correct. But
over election law, there are hundreds of cases dealing with the question of is an election law provision mandatory or directory, and they're scattered, I will tell you. I mean, they're scattered. The results are scattered. But that basic dichotomy is throughout our election law all across country.
I actually, so I can tell you this. Now, obviously, we've been on an abbreviated briefing schedule here. I have cited in my brief decisions from other state courts which seem to reflect the overwhelming majority view that instructions like we have here must be complied with, and rejects this idea of a substantial compliance standard.
Into the legislative acquiescence issue. So we're proceeding under 17A, right, is how you frame this. Or how?
Or yes, I believe so.
On that basis, usually under 17A, we say that where an agency has acted in a particular way over a sufficient period of time and the legislature hasn't taken any action to correct the agency's interpretation or practice, that should carry some weight in how we interpret the statute. So what bearing would that doctrine have in this case? And why is Mr. Langholz correct, indicating that the legislature revisits this statute fairly frequently? This 88 decision has been out there for a long period of time. It seems like they've adopted it or at least not objected to it.
Well, certainly, you can always, in a statutory interpretation case, think of some language that would be more clear to help your client win. And this is no different. And the legislature has not enacted the language that I might come up with that I wish existed that would make sure my client wins beyond a shadow of a doubt. It's very hard when you read this court's cases to know exactly what does or does not trigger this acquiescence doctrine. Now, going the other way, there's plenty of cases where you can see the court decides an issue in a particular way, and then the legislature responds by changing the law, clarifying the law, social host liability. That sticks out in my mind from law school, where the legislature put the citation to the Northwestern Reporter in the statute saying that that's not the law anymore. You can find those examples. Going the other way, the acquiescence in some decision, I don't know how notorious it is. The very fact that Mr. Langholz has to dig up a copy of the Dvorak panel opinion and attach it to a notice of additional authorities, it's not something that's published. I don't question that it's a public record.
And there were lots of legislators and the people in that world who were very much part of that proceeding, correct? That would have knowledge of it?
I can't say.
Or stated on the document, and who signed it?
Certainly. I mean, obviously, you have the three statewide officials who are on the panel, although actually only one of them signed it. And I don't question that the document that the court has been provided is authentically the document that came from the Secretary of State's office. I want to be clear. But it's signed by the Attorney General. It's not signed by the other two people on the panel. It doesn't have any kind of file stamp on it. I don't really know what that is. And
Consider it. I'm not sure what you're saying on that.
it is. I mean, it probably is that.
Does it merit?
It certainly does not merit any weight on the legal analysis of what does 4315 require. I don't know what legal arguments were made to that panel because you cannot glean that from that document. This court clearly has an independent duty and authority to interpret what the law requires.
Let me ask you what I was asking the other side about 4314C. As I understand Mr. Langholz's answer, consistent with their position that you can't reject a signature if the ground is not listed in C. He said that if somebody some signer lives outside the district but not obviously outside the district, that signature would still have to be counted or would not be subject to objection. I take it you disagree with that.
Correct.
Anybody outside the district would be a valid grounds for objection.
I think this gets into something that, frankly, I was hoping to get to earlier, but that I think you can also read 4314 as listing reasons why a signature line cannot be counted. And you can read 4315 as to what it takes to be a valid signature. And those two things are not necessarily in conflict. Like
So there is another canon that's in play here, right? We don't read statutes to have the legislature put in surplus language, right? And if 4315 says signature is mandated, but 4314 2C says here is when we strike lines, did they really need 2C? I mean, doesn't 4315 already say it? Don't we have to give meaning to both statutes?
The court does have to give meaning to both statutes and not read one of them as having no effect. And so frankly, the argument of the date of signature requirement in 4315 that my friends have made to this court this afternoon would read that out of the law. Now, the legislature, as it, I think, from time to time has a belt and suspenders approach on 4314 2C and gives examples of why signature lines don't get counted in that review. But
Everything's mandatory. What work does 43.14 do?
well, it gives a textual basis to not count signature lines where, for example, as Justice Mansfield has identified, the signer is not in the district. Now,
Say things like such as. It's pretty articulate as to which things will not count. It doesn't have the such as or for example, does it?
I don't see, I want to make sure I understand your question, Chief Justice. I don't see anything in 4314 2C that purports to be, this is the exclusive list of reasons why a signature line is not counted.
In 2A and 2C, shall not be counted or shall be counted only if. That's pretty definitive that they're saying don't do it. And then in 15, there's no such language. I struggle with that.
I'll give you another example that came up during the contest proceeding, which is not being appealed here, okay? Duplicate signatures. There were several counties in several of these petitions where people signed it more than once. I can't remember which candidate it was. Somebody signed it 3 times on the same page, okay? Things happen, right? And so if I was up there and you were down here, I could ask you, show me in 4314 2C where it says duplicate signatures don't get counted. And now,
discounted. I think 14.14 talks about which ones shall be discounted without further discussion. You're talking about a situation where perhaps evidence would need to be presented or a discussion made to persuade. By the way, I can see why it happens more than once. In a small town, you have these things pasted at every cafe in town, and they think they're signing for all candidates, and it's the same one.
Which is why ordinarily these cases don't reach this court, because ordinarily candidates file more signatures than you need to. And that's why we're here. You don't come in right at the line. Inevitably, some signatures are not going to count. I cited in the brief the Secretary of State's candidate guide, which is excellent. I mean, as an election lawyer, I would like to pretend that this stuff is all mysterious. It's not. You download the primary candidate from the Secretary of State's website and primary candidate guide, and it tells you every single thing you need to do this right. And it says right in there, file more signatures than the bare minimum because some will inevitably not be counted.
Argument and get your best spin on it, argument. And that is the substantial compliance argument, as I understand it. This is kind of springing off the Hubler decision. And it's that, well, in this case, as you pointed out, I mean, I think there's a blank, and then there's a zip code, and then there may be somebody's birthday and the date. Your opposition says, well, yes, but we can extrapolate. I'm summarizing their argument. We can extrapolate because on the petition, we have dates in proximity. These signatures are sandwiched in between. Therefore, there's substantial compliance. Give me your best argument contrary to that.
court's case law, Grover, is cited in the brief, does not lend credence to that use of the term substantial compliance. I can give you an example of substantial compliance where we didn't object to a signature line. It's not.
For a minute, are you saying that as a matter of law, you think substantial compliance doesn't apply to these election statutes that we're talking about?
I think we need to define it first.
Did you go ahead and define it? Yeah.
So at the panel, substantial compliance, and the Dvorak decision, substantial compliance means we're not going to enforce the date requirement. Don't bother us with what the code says. We're just not going to enforce it. That's not substantial. I mean, no, that's not a lawyerly use of a term, substantial compliance. That's just saying we're not going to enforce the date requirement. We're going to.
In this case, was it? I mean, it was, we can tell from the context when these people signed, and there isn't anything that looks out of sorts here. It wasn't like the hypothetical Justice McDermott gave of a whole petition that didn't have any dates on it, right?
Well, I think it was pretty close to that. Maybe there was a little dramatic effect in how I relayed that, but it was, it makes me think of, from 2020, this court's decision in Lulac versus Pate, where the court enforced the voter will provide this information on an absentee ballot request form. And that requirement is valid, and the voter has to do that. The panel never really articulated what's the standard. They just said, we feel comfortable with these undated signatures.
Some other language we haven't talked about yet I want to ask you about. 4314.3 says, if the nomination petition lacks a sufficient number of acceptable signatures, the nomination petition shall be rejected and shall be returned to the candidate. So that word acceptable, like if my spouse tells me I did an acceptable job, that's not normally a compliment. That sort of sounds like substantial compliance kind of language, doesn't it?
That's not my reading of it. I think if a candidate shows up at the counter, let's say a candidate has made some sort of serious mistake about how many signatures the candidate needs. They show up and they drop off a petition and it's clearly below the line. What the law thankfully says is the Secretary of State's office is supposed to say, hey, you don't have enough, go get more.
I want to interrupt because that's a similar, I want to answer this question within that. But if you assume that as a court we say substantial compliance is enough, do you think the facts of this case, those 3 signatures, do they substantially comply?
And that's because of the city annexation case cited in the brief, which is what the panel relied on in front of the district court, that definition of substantial compliance. This court found no substantial compliance there. And as an example of something where it would have been wrong for us to object to a signature. So it's on page 40 of the administrative record. There's a signature page where it looks like spouses signed, and somebody, the first signer fills out address and city and date, and then the next person signs and puts same as above. Now there's separate authority that you can do ditto marks across the page, okay? I'm not going to come to this court and say that signature line doesn't count, because you look at it and you can say, okay, they said same as above, they adopted the line above them. That's not what we have with these 3 signature lines here.
The substantial compliance definition from Gorman. So there it said it's compliance in respect to essential matters necessary to assure the reasonable objectives of the statute. And if the reasonable objective of the statute requiring the date is to avoid fraud and maybe to ensure that this person is an eligible elector, and you can tell because the person right above signed it on February 7th and the person right below signed it on February 7th. Why does that not meet the essential objectives of the statute?
Because the essential objective of the statute is to require the signer, him or herself, to put the date down.
Just for a technicality so that someone can get someone thrown out of a ballot. what's the purpose of the date, and why is not the objective, the essential objectives of requiring all these signatures, including a date, not met, where you can see that from the person right above and right below what date this person actually did sign, even if they didn't actually sign it themselves.
The assumption that one would make when reading the page is not absurd, to assume that the date is in this sequence. What I can tell you is that the legislature has said that the signer, him or herself, must provide the date of signature. So you could easily ask that question in the way of, suppose you have a whole sheet of signatures where the electors don't fill out the date column, and then the circulator, in front of cameras and witnesses, writes the date down for everyone that they signed it. And everyone will agree that that's the correct date, okay? Under the law, that page is not valid because the signer, him or herself, must provide the date. Just like in Gorman, the legal description must be correct for a city's annexation to occur, even if the map that comes with it is right. The legal description is wrong. Anybody who would have wanted to know what land is being annexed in Gorman, I guarantee you, would have looked at the map. They would not have looked at the legal description and started counting meets and bounds in their head.
Southwest versus southeast, that's a pretty significant error in the legal description. And legal descriptions are very important in land records. I'm just trying to figure out what the importance of the date here is, that we want to avoid any technicality or any technical violations, and actually show that there's a real need here for those dates in this particular case.
The reasons that Justice McDonald identified previously, and the anti-fraud measure of making the signer, him or herself, inscribe the document with the date rather than letting somebody else fill it in or just guessing.
You're not alleging fraud on those three?
I understood the question to be what is generally the purpose. I agree. We're not saying that somebody fraudulently put these lines on the page. I'm saying that the legislature has created this requirement, and I'm about to run out of time. May I finish answering your question, Chief Justice? The legislature has created this requirement, and this court's cases on statutory interpretation all recognize we can all think of ways in the alternative that we might accomplish some goal of the statute. But the function of the court is to implement the fair and best reading it can of the directions of the legislature, how to implement it. Those directions have required the elector to write the date of the signature.
So the recusal issue was litigated below. Is that off the table? Is that anything we need to decide?
I didn't file a cross appeal, and I think it is, at this stage, only relevant to the fact that in the morning of the panel hearings, this date objection, when it's made against the Attorney General's petition, is granted. There's a signature line that's not counted by the panel, and then that rule changes in the afternoon when Ms. Finkenauer's petition is being challenged. But we are not, we have the square legal question here today in front of the court, and I can't, in my own mind, answer the appellate practice question of what happens if I cross appeal within the next 27 days or whatnot, and we're not going to go there.
Chief, may I ask Mr. Ostergren, let me ask you about 4324-1A, which is discussed in the briefs, but you haven't really, as I recall, talked about it in your argument. There's the sentence that says, objections relating to incorrect or incomplete information for information that is required under section 4314 or 4318 shall be sustained. You're saying we should also add 4315 in there, right?
Well, I would love to say that, but I think that's stronger than I need to prevail here. the issue with the header on the petition. What the legislature has done is made it non-discretionary to strike a page in the petition if any of the required information is not present because of an experience where the panel did not take that requirement seriously. And so the legislature went back and amended on that question. There's no real meaningful fact dispute that you can get into like you could about, is somebody an eligible elector? Are they old enough? Are they a felon? Are they a U.S. citizen? If you look at the header and the candidate hasn't listed the candidate's county of residence, or the blank where the county of these electors has not been filled in, those are just clear-cut disqualifiers to that entire sheet. And there's the direction from the legislature just simply not count that page if that objection is made. So that's how I would respond to that, Justice.
Up on that, 4314 is not limited just to the header. It also discusses, it has these requirements about when signatures aren't supposed to count as well, right? And 4324A1 references the entirety of 43.14, not just the part discussing headers.
Correct. That's correct, Justice Oxley. Yes. We ask that you affirm the district court. Thank you.
There's been a lot of discussion and statements from my friend Mr. Ostergren that we're reading the requirement in 4315 out with our interpretation, or that it's no longer required.
Sorry to interrupt you so soon, but can you address the duplicate signature argument?
Yes, and my response would be that you're not striking a signature and not counting it when it's a duplicate signature. I mean, you're not counting it twice, and it's implicit in.
Where's the statutory text that says you get to disregard a duplicate signature? I mean, your position is this text is exclusive. Only signature lines that have the defects identified in 4314, 2, C, and D are excluded. It seems like you would concede that there are at least some extra textual grounds for striking a signature line.
I think it can be implied into the requirement of a signature that you're not going to count it twice. But yeah, I mean, there are some implied there. There's no provision anywhere in Chapter 43 that says duplicate signatures can't be counted. That's correct. And
45.1, which requires the 3,500 signatures from eligible electors.
That's correct, and also the counting of when you're counting how many signatures are in a county. It's not that you're striking any signature. That person's signature is counted. That it's just when you're counting, you're only going to count it once, rather than there. But that, it's a valid point that could be something, as the legislature is clarifying, could be put in there. But I want to be clear that the requirement being there in 4315, still does have effect. A person out collecting signatures, knows, because it's a requirement, that they need to get dates. If somebody doesn't want to put down a signature and the collector is trying to make sure the law is followed, they can say, it's required, I need your signature. And that has benefits. It will help with the eligibility, sorts of discussions, and there would be consequences to not having that signature as well. And so the question...
Consequence. I mean, if it's not going to matter whether it's there or not.
McDermott, it's correct. There's not a consequence. I mean, that's the second step of the issue, whether it's required and what is the remedy, what is the consequence. And we look at the statutory scheme to see, what the consequence should be of not having it. And in the scheme as it's written now in 4314 and as well as in 4324, we know that objections are supposed to be sustained from missing things in section 4314 and 4318.
Wrong with this reading, and I think opposing counsel had mentioned it, that 15 sets forth the requirements for what is a valid signature. And 14 sets forth some grounds on which an otherwise valid signature could be challenged. So, for example, the person is not an eligible elector, the address that's otherwise a valid and real address falls outside the district, or in sub D, there's information that might be correct, but that was crossed out or redacted. Wouldn't that reading give effect to both 14 and 15? You would have a requirement of a date for a valid signature and then grounds for exclusion under 14.
Well, so I think 4315 is a little bit broader than just a signature, and it's also, I mean, if by its text is about the requirements for signing the signature and the requirements to the signer, as opposed to the question of, ultimately counting the signatures. I mean, the language of 4314.2 is signatures on a petition shall be counted only if, and going on to talk about the signature lines. Briefly, Justice Mansfield, you asked the question to my friend Mr. Dickey about could 4314 be focused on the initial review by the Secretary of State, and I think it does speak to the initial review as they're coming in. But then, in the language we were talking about just at the end with Mr. Ostergren, it's brought back and brought into the objection process, and it's the focus of the objection process by the new language just issued last year that says objections relating to incomplete or incorrect information in 4314. So it cannot just be limited to the review by the Secretary of State. I do think there is, although I've talked about the logical extension, but that doesn't have to be reached, here, and it is also a fair interpretation of the scheme that those are mandatory. That's when it becomes the mandatory situation where it's been spelled out that that's the remedy. But then in 4315, that there's more discretion. It's still the long-standing substantial compliance version of the review that the panel has been doing for some time. And under the panel's view and that substantial compliance, the blank forms, that are entirely blank, very likely would not comply, with a substantial compliance standard that's looking at 4315. So
Mr. Langholz, in subsection 2D, which addresses 14.2D, it talks about information, required information, that is crossed out or redacted at the time the papers are filed. To what does required information refer? And I guess earlier you were talking about somebody collecting signatures and saying the date is required information. Is it your understanding that required information, at least there, would require the date?
I think at the very least it covers the required information in C, immediately above, where it's talking about the residential address and street and city number being required. Again, D doesn't, since it's a crossed out line that we're doing it, because of crossed out. I suppose it's an interesting question if you only crossed out the date but left everything else. Would it still be a valid signature, but you've crossed something out?
A signer scratches through a date for some reason. Under this, that would not be a valid signature. If the signer took white out and redacted the date, that would not be a valid signature. If the signer just didn't include the date at all, then that has to be a valid signature. Is that right?
That's an odd result. It would be one interpretation. I think you could also interpret required just to be referring to the information immediately above in C, and that would avoid the situation that a signature that would, absent a date at all, could be counted, but one that had just the signature crossed out, couldn't be counted. I think.
Wouldn't that just eliminate the word requirement completely from 15 as applied to date information?
As it's still required. It would be legitimate for a signature collector to say, I need to get this from you, and for a campaign to refuse to count that signature because they don't have it and decide to collect another signature as well. The issue is whether it will be counted and disqualified from the nominations. And I appreciate the additional time, Madam Chief Justice, and I ask that the district court be reversed.
Madam Chief Justice, and may it please the court, Justice Mansfield, Mr. Ostergren conceded the question presented with respect to standing when he admitted that there is no concrete injury in fact. You gave him the opportunity to stand up here and say that his client's concern is that Abby Finkenauer poses a more stronger challenge to their preferred client, but he refused to do it. But even if he had, that would not be a sufficient interest to satisfy the requirement in Dickey versus the Ethics and Campaign Board, which is a legal and a personal.
You're right about that, but that was I think that was a 17A case. So you had to show that you were an aggrieved person, whereas I think Mr. Ostergren has a point that here you have statutorily conferred standing. And that's really an issue we haven't confronted, as I recall, whether the legislature can confer standing on someone that otherwise would not have an injury in fact in the classic sense of the term, right?
With that interpretation of Dickey, and I would ask you to go back and read the briefs, because I raised that precise issue that 68B and 17A specifically gave me statutory standing. And in fact, if you compare it, it gave me more statutory standing. So for example, 68B says that any person may file a complaint alleging that the committee has committed a violation under 68A. Any person, felons, 16-year-olds, mentally incompetent.
I don't want to take up the time arguing this case with you, but I'm not going to let that one pass, because you were right at the administrative level, that was good enough. But then to get into court, you had to get through the 17A hurdle, which required you to be an aggrieved party, and you couldn't do that. That's what we said in the opinion.
Well, I mean, I guess I'll go on and say that the statute says that judicial review of the actions of the board may be sought in accordance with 17A. And I guess they've conceded this is a 17A judicial review. So if you go to 17A.19.1, this is final agency action. I don't believe they've argued it's contested case hearing. They have to argue that they've been aggrieved by it. And so there's the 17A standing, and then there's also the common law standing that this court has imposed. I've argued multiple times, as Justice Apple has, that there's no textual basis. I've lost every time. The objectors are not arguing, by the way, to overrule any of that precedent, nor would they have any good basis to do that. And so if this court sets the analysis of the Dickey decision versus the facts of this case, then it requires that you reject their petition for a lack of standing under 17A, but also under the case and controversy requirement adopted by this court.
Could enforce the signature requirements.
Enforcement mechanisms. The first is, I think maybe Justice Mansfield or Justice Oxley brought it up, which is the initial point of contact in the Secretary of State's office. So when that petition came in and it didn't have the date, they hand it back. And I guess, Justice McDonald, that gets to your question about agency deference. And I don't want to go down the Chevron rabbit hole, but that ought to count for something, that the Secretary of State's office took a look at it as initial instance and did not return it for having insufficient signatures. The second party would be just the same party as in Chido versus Bisignano, a competing candidate committee. I haven't thought it all the way through. Perhaps a competing party candidate, so perhaps a Republican candidate may have standing, perhaps even a competing party, but that's not what we have presented here. Justice McDonald, I suppose you could interpret 15 in unison with 14, but of all the potential options that have been set on the table, I think that's the most strained reading, particularly in light of the amendment last year, which specifically enumerated strict compliance for 14, but didn't mention 15. So unless there are any other questions, we ask that you reverse the district court.
Thank you. Schmett and Pellet versus State Objections Panel and Abbey for Iowa is hereby submitted, and court is adjourned.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.